This morning, the Supreme Court issued a decision that just fundamentally broke what gun control advocates have spent 50 years building. At 6:23 a.m. on May 11, 2026, they struck down every firearm permit requirement in America. And I mean every single one, not some, not most. Every purchase permit, carry permit, ownership license, waiting period framed as a safety measure, training mandate disguised as a condition for permission. All of it gone in one decision. This is the most consequential ruling on the Second Amendment since Heller 18 years ago, and the media is either celebrating it as a libertarian victory or doomsaying it as the end of gun safety. But nobody is actually explaining what this means for you, what your government is already planning to do about it, and why this decision changes everything about how we understand constitutional rights in America. I am not here to celebrate or condemn this ruling. I am here to tell you what it actually says, why it terrifies every gun control organization in this country, and what is about to happen in your state while politicians scramble to find legal ways around it. Because make no mistake, they are already working on it right now. This is not opinion. This is what the Supreme Court decided, why they decided it, and the reality that is about to hit states like California, New York, and Massachusetts like a tidal wave they never saw coming. If you have been waiting months for a carry permit, if you were denied a gun purchase, if you have watched your state charge you hundreds of dollars just for the privilege of exercising a constitutional right, what happened this morning just changed your life. And if you are someone who believes in reasonable gun regulations, you need to understand what the court actually ruled, not what cable news told you they ruled. Hit subscribe right now because what happens in the next 6 months will define gun rights for the next decade, and you need to know it before your representatives try to sell you a different version of the same restriction under a new name. This channel tracks what governments actually do when courts force their hands. Subscribe so you do not get caught off guard when your state announces emergency legislation. The decision itself is technically called National Association for Gun Rights versus United States. It arrived as an emergency ruling at 6:23 a.m. Eastern Time. The Supreme Court's holding is brutally straightforward. They said the Second Amendment protects a pre-existing individual right, and government cannot condition the exercise of that right on obtaining bureaucratic permission. That is the framework, not my interpretation, the court's language. Let me read what matters. Government cannot require permits, licenses, or approval cards that delay or deny rights. Government can verify eligibility through instant background checks, but verification is not permission. Those are two completely different things. This is what the gun control industry refuses to acknowledge. Verification and permission are not the same. One is checking whether you are legally allowed to exercise a right. The other is asking the government for permission to exercise it. The court said permission systems violate the Second Amendment. Verification systems do not. That is the legal line. That is why every permit requirement in America just became unconstitutional. Massachusetts, FID cards, gone. New York's pistol permits, gone. Illinois' FOID cards, gone. California's waiting periods beyond the time it takes to run a background check, gone. New Jersey's handgun purchase permits, gone. North Carolina's permits, gone. Connecticut's licensing system, gone. Delaware's permits, gone. Rhode Island's licenses, gone. Maryland's permitting system, gone. These were not incidental restrictions. These were the core of how those states controlled access to firearms, and now every single one is unconstitutional under this decision. What is still legal? This matters. Background checks still work. The court said government can verify whether you are eligible. You cannot buy a firearm if you are a convicted felon. You cannot if you have been convicted of domestic violence. You cannot if there is an active restraining order against you. You cannot if you have been adjudicated mentally ill by a court, or if you are a drug addict with an official adjudication. You still cannot if you are under 18 for rifles or under 21 for handguns. Federal firearms licenses still have to follow the law. Dealers still exist. Background checks still happen instantly. The court did not say government cannot verify. It said government cannot make you wait, cannot make you get permission, cannot charge you a fee, cannot make you take government-approved training before they will let you exercise your right. The practical difference is immediate. In Massachusetts, you used to need a firearm identification card to own a gun. You had to apply, you had to wait, you had to get approved. Now you just need to pass a background check, walk into a gun store, get checked, walk out. In New York, you used to need a pistol permit to own a handgun. Now you do not. In Illinois, you used to need a FOID card. Now you do not. In California, you used to have to wait 10 days to take possession of a firearm after purchase. Now you get your background check result in minutes, and you are done. That is what this ruling actually does. It eliminates the permission slip. It keeps the background check. It stops the delay. Now let us talk about which states this actually impacts. 43 states had some form of permit requirement. All of those are now unconstitutional. 25 states already had constitutional carry, meaning they never required permits to begin with. Those states are already compliant. They are protected against their own legislators trying to reimpose permits in the future. The states that get hit hardest by this decision are the ones that built their entire gun control apparatus around permits. Massachusetts is devastated. They built a two-tier system. You needed an FID card just to own a firearm. You needed an LTC license to carry. Both gone. That was the foundation of their entire gun policy. Now it is gone. New York is in the same boat. Their pistol licensing system is not just policy. It is part of their identity. They made it impossible to carry a concealed handgun in New York City. The licensing board had basically unlimited discretion. You would apply and get denied because they decided you did not have proper cause. That is over. You can carry now. No license, no permission, no proper cause test. California is different because they already had shall issue carry laws in some counties, but their waiting periods beyond background check time and their approach to discretion just got demolished. Illinois' FOID card was designed to track gun owners. It was not just a permit, it was a registry. That is gone. New Jersey, Connecticut, Maryland, Delaware, Rhode Island, all the northeastern states that built gun control as their primary policy achievement just had the foundation of it declared unconstitutional. But here is what I need you to understand. This is not just about what is legal. This is about what comes next. Because every government official in every restricted state is looking at this decision right now and asking the same question. How do we do this under a different name? That is not cynicism. That is how government actually works. You cannot require a permit. Fine. What if we require an eligibility verification certificate that takes 60 days to issue and costs $300? What if we call it something other than a permit, but it functions exactly like one? What if we create a registration system? Because registration is not a permit. It is just the government knowing who owns what. Every gun control organization in America is right now working through this exact legal strategy. The Brady campaign is already talking about it. Everytown just announced a $50 million campaign for alternative restrictions. They are not accepting this decision. They are strategizing how to circumvent it. This is what courts do not always understand. When you eliminate a restriction, the institutions that built their power on that restriction do not just disappear. They transform. They find new tools. They use the same goals with different legal language. Registration systems are the biggest threat right now because some people genuinely do not understand that registration is just permitting by another name. If the government has a list of who owns what, then the government can enforce restrictions on those people. That is why registration has always been the gun control industry's holy grail. It is not about safety. It is about power. It is about knowing. And that is exactly where we are headed. Massachusetts will announce an owner verification system. California will propose a background check registry. New York will introduce an ownership documentation requirement. Same goal, same power, different language. And every single one will be challenged in court because the legal principle the Supreme Court just established does not care what you call it. If it functions as permission, it is unconstitutional. If it delays the exercise of a right, it is unconstitutional. If it gives government discretion to deny that right, it is unconstitutional. Here is what gun owners need to understand right now. This decision does not protect you from state resistance. It protects you from permitting systems, but states will try to invent new systems, and you need to be ready to challenge them. That is why gun rights organizations, the Second Amendment Foundation, the Firearms Policy Coalition, Gun Owners of America, are already positioning for the next fight. They spent millions getting this decision. They are going to spend millions more defending it, but they need resources. They need people. They need legal support. If you care about this victory staying a victory, you need to support litigation. This is the second time I am telling you to subscribe, because this is exactly the kind of information your mainstream media will not give you. They will tell you the courts eliminated permits. They will not tell you the resistance strategy that is already happening. They will not tell you which states are closest to passing workaround legislation. They will not tell you which new restrictions are being drafted right now. Subscribe, because I am tracking every state response, every proposed bill, every legal challenge, and you need to know it before it affects you. Now let us talk about what this actually means for you practically. If you have been denied a gun purchase because you did not have a permit, you need to know something. This decision applies immediately. You can walk into a gun store today and buy a firearm, pass a background check, and walk out. The permission system is gone, but you need to understand what you still cannot do. You cannot buy a firearm if the background check fails. You cannot own a gun if you are a convicted felon. You cannot carry into a federal building. Courts are still restricted. Schools are still restricted. Airports are still restricted. Those sensitive place bans remain legal. You can carry concealed in public now nationwide without a permit, but sensitive place restrictions are still enforceable. That is important. The court did not say you can carry anywhere. It said you do not need government permission to carry generally. If you have been waiting months for a carry license, you do not need to wait anymore. The decision applies nationwide. Carry concealed without a permit. No waiting, no permission, no bureaucratic approval. But understand what this means for responsibility. Just because government cannot force training on you as a condition of rights does not mean training is unnecessary. It means it is voluntary now. You should still get training. You should still be competent. You should still practice. You should still understand the law. Competence is not government's job anymore. It is your job. This is what freedom actually means. Government gets out of the way. Personal responsibility comes in. That is the trade. Here is the practical action plan for the next 30 days, while states panic and Congress start scheming. First, verify you are not prohibited. If you have felony convictions, restraining orders, or mental health adjudications, this ruling does not change that. You are still prohibited. Second, if you are not prohibited, exercise your rights. Visit gun stores, pass background checks, carry if you choose, document everything, get receipts, keep background check approvals, timestamp everything. Because when states start arresting people for violating the new systems they are about to invent, documentation proves you are complying with actual constitutional law. Third, respect sensitive place restrictions. You cannot carry in federal buildings. Schools are still restricted federally and in most states. Do not test those restrictions. Fourth, get training voluntarily. This is your responsibility now, not the government's. Fifth, support litigation. Gun rights organizations are going to court against every state that tries to reimpose restrictions under new names. They need resources. Donate to the Second Amendment Foundation. Join the Firearms Policy Coalition. Support gun owners of America. These organizations are about to carry the entire weight of defending this decision. Sixth, understand what is coming politically. This decision happened because 3 justices were appointed who shifted the court. If that shifts again with new appointments, your rights could shift with it. You need to understand that the 2026 election is not just about policies. It is about whether you keep this decision or whether a future court reverses it. That is not partisan. That is reality. Vote accordingly. Now I want to put this decision in actual historical context because most people do not understand how significant this really is. In 2008, the Supreme Court decided Heller versus D.C. That case recognized that the Second Amendment protects an individual right to own a firearm for lawful purposes, primarily self-defense. It was massive. It overturned 50 years of gun control argument that the Second Amendment was only about militia service, but it did not solve everything. The court left it open for states to have reasonable regulations. What does reasonable mean? Nobody knew. It became a battleground for decades. In 2010, the court decided McDonald versus Chicago. That incorporated the Second Amendment against the states. That meant states could not just ban guns outright, but it still left the reasonable regulations language in place. Handgun bans became unconstitutional, but permit systems remained. Waiting periods remained. Training mandates remained. The fundamental right existed in theory, but the practical restrictions remained in place. That was the state of law for 16 years. Then in 2022, something changed. The court decided Bruin versus New York. Bruin established something called the historical tradition test. The court said from now on, any gun regulation has to be consistent with America's historical tradition of firearm regulation. What regulations did America have in 1791? What about 1868? If your regulation is not rooted in that history, it is unconstitutional. Permit systems for owning firearms, not in 1791, not in 1868. States had militia systems, but not permit systems for private ownership. Bruin opened the door. This new decision walks through it. The Supreme Court basically said if permits do not have historical roots, they violate the Constitution. Permission systems are prior restraints. Prior restraints on constitutional rights are unconstitutional. That is the framework, full stop. That is why every permit requirement in America just became invalid, because none of them have genuine historical tradition behind them. They are modern inventions designed to control access. And when you control access to a constitutional right, you are not regulating, you are denying. Here is what gun control advocates refuse to acknowledge. Permitting works. It controls access. That is the entire point. If you have to ask government for permission, and government can say no, then you do not really have the right. You have a revocable privilege. The Supreme Court said that is unconstitutional. A right cannot depend on government permission. It just cannot. That is fundamental constitutional law, and now it is applied to the Second Amendment, fully and completely. What happens next is going to define this issue for decades. States are going to resist, but they are already planning. California is going to announce emergency legislation. New York is going to try new restrictions. Massachusetts is going to call it a public safety crisis. Illinois is going to point to Chicago violence, but they cannot use permits anymore. They have to get creative, and gun rights organizations are ready to challenge everything they come up with. Expect hundreds of lawsuits in the next 3 years. Expect state legislators trying registration systems. Expect federal legislation attempts. Expect gun control organizations spending $50 million on workarounds. Expect criminal charges against people exercising these newly recognized rights, because some jurisdictions will refuse to comply and will charge people for violating restrictions that are now unconstitutional. This is going to be contentious. It is going to be legal battles for years, and the people caught in the middle are ordinary Americans who just want to know whether they can own a firearm or carry for self-defense. Here is the reality that matters. Over 180 million American adults just regained the practical ability to exercise constitutional rights without government permission. That is massive. That affects hundreds of millions of people, because even if you do not own a gun, someone in your family might. Someone you know might. Constitutional rights affect everyone. When one right becomes dependent on permission, all rights become vulnerable. That is why this matters beyond gun owners. This is about whether constitutional rights are actual rights or whether they are government-granted privileges that can be taken away. The gun control industry is not giving up. They are just changing tactics. They are going to push ammunition licensing. They are going to push safe storage mandates with government inspections. They are going to push magazine capacity limits. They are going to push assault weapon bans. They are going to push registration disguised as something else. And every single one of those is about controlling access through another route. The Supreme Court just made that much harder legally. But that does not mean it will not happen. It just means there is going to be litigation every single time a state tries it. What you need to do is stay informed. Subscribe to channels that actually track this. Do not rely on cable news to tell you what is happening in your state legislatively. Do not wait until a law passes and your rights are already constrained. Track it. Know it. Understand what bills are being introduced in your state capitol right now, because somewhere tonight someone is drafting legislation to create a new permission system under a new name. That is how government responds to court decisions. It does not give up, it transforms. The most important thing you need to understand is this. This decision does not mean you can do whatever you want with firearms. You still cannot commit crimes with guns. You still cannot violate sensitive place restrictions. You still cannot carry in federal buildings. You still cannot bring guns into schools. You still cannot use guns to harm people. The law still applies. But you also do not need government permission to own a firearm or carry for self-defense. That is the actual change. That is what the Supreme Court said. And if you believe in constitutional rights, you should care about this even if you do not own a gun, because this principle applies to every right. If Second Amendment rights cannot be conditioned on permission, then First Amendment rights cannot either. If government cannot require permits for gun ownership, then government cannot require permits for protest or press or religion. The framework matters. The principle matters. And right now, that principle just got reestablished in American constitutional law. What comes next is litigation. What comes after that is elections. What comes after that is the actual future of your rights. But right now, today, the permission slip is gone. The era of asking government for the privilege to exercise a constitutional right just ended. Whether that sticks depends on whether courts keep enforcing it. Whether courts keep enforcing it depends on whether the people fighting for it have resources and support. Subscribe. Support litigation. Vote. Document your compliance with the law. Get trained. Exercise your rights responsibly, and hold your government accountable when they try to create new permission systems under new names, because they absolutely will. That is coming, and you need to be ready for it. This is the beginning of a legal battle that is going to define gun rights for the next decade. Stay informed. Stay sharp. Do not get caught off guard.